it would be interesting to give a breakdown of the different types of objections and when they're used. All right, let's see if I can do some common ones. I just had a trial. Hearsay, you hear about that a lot. Hearsay is an out-of-court statement made by somebody else who's not in court that's offered for the truth of the matter. The person on the witness stand named Mike is saying, Steve said that. And if you're a lawyer like me, anytime you hear so-and-so said that, you start getting this twitch. Because that's the hearsay twitch. Steve said that, oh, hearsay. I want to be really careful here. This is my twitch. I am not making fun of anyone. This is literally what happens to me. I want to be very clear about that. But we have, last I knew, 26 exceptions, which are exceptions because the law has said, look, even though that's hearsay, it's still reliable enough to come in as evidence in court. An easy example is an excited utterance. An excited utterance is something you scream right after it happens. You see this car crash and I just scream out, it was the blue car! Oh my God! I don't have time to make up a lie. It's right off the top of my head. That literally, the law recognizes the idea that, hey, if you say something right after it happens without thinking, you're probably telling the truth. I think that's generally true in real life. A document that a company creates and keeps and saves and does a few other things with. Basically, it's a company record. That is hearsay. It's the company's record. It was created outside of court. But when you're in court, that company record is usually allowed in as evidence because it's a business record. Business records are generally reliable because businesses keep good records. Moving away from hearsay, because that's an easy one to get bogged down on. Let's talk about leading questions, which is the most nitpicky, annoying objection in the world. So, when you are doing a direct examination, meaning you've called the witness to the stand and that witness is in your favor and you're asking that witness questions, you have to ask open-ended questions. Usually start with who, what, where, when, why, and how. I'm gonna give you a different one. Then what? Basically, you're just saying, tell me. You're right, that's it, tell me. And you're not introducing the answer or giving the witness any facts. You're just asking them, what happened then? Leading questions, not allowed when you are on a direct examination, completely allowed and preferred and recommended when you are cross-examining a witness. When you're cross-examining a witness, almost all the time, you should be only asking leading questions. So instead of asking what happened then, open-ended question, you are telling the witness, this is what happened then, correct? In open-ended questions, the witness is telling the story. In leading questions, the lawyer is telling the story and asking for confirmation by the witness. Now, I'm gonna say yes inside my head, and I want you to do the same thing after every statement I make, because that's what this basically is. It's agreement. So you drove to the store, you parked in the parking lot, you went inside, you then walked down the aisle, you then slipped, then you kept shopping for 2 hours, like you were totally fine, and then you went back out to your car, then you went home, then you went to your pool, then you laid back and relaxed, and then you decided you didn't want to go to work the next day, and that's the first time that you said your leg hurt. All those are leading questions as opposed to, what did you do on Saturday? Oh, I went to the grocery store. Yeah, how'd you get there? Oh, I drove. When you got there, what did you do? Oh, I went inside. Where'd you go? Oh, I went down the aisle. Now you see how that takes a little more time, effort, slows down the pace. I once did a trial where everybody agreed we were going to lead every witness. Main reason was all the witnesses were so scatterbrained and all over the place that before the trial, I said to the other lawyer, this is going to take forever and it's going to be extremely confusing because all these witnesses are all over the place. You ask them what happened next and they start talking about when they were born. So do you want to lead everyone? And the lawyer goes, yes, let's just lead everybody. And we kind of had an agreement that it would be more or less fair leading questions. We would say what we knew really did happen. Nobody was going to get there and lead and say, well, then you agree that you were at fault. You know, that would be kind of a breach of our agreement and also just a screwed up thing to do. So we did leading questions for almost every witness, moved the case along, got to a resolution that my side won, his side was unhappy, and that's the way it should be, right? Every case. Other objections that you might hear not in court is the form objection. If you ever watched a deposition, maybe you've seen Bieber. Recently, I've been watching this deposition of a guy named Jeff who's a New York financier. Heard he had an island. Maybe you guys have heard of him. I don't know. I keep waiting on these records to read them and see like what his business was and what exactly he did and who was involved. And like 90% of the country, both Republicans, Democrats, and people like me who are just somewhere out there in the political sphere, all want to see these documents. So anyway, I was watching this guy's deposition and I heard objections to the form.
Is it true, sir, that you have what's been described as an egg-shaped form? vague and definite. These types of questions are not only argumentative, but directed in a manner to embarrass Mr. Epstein.
What a form objection means is that you've phrased the question wrong. Maybe you've asked a leading question when you can't. Maybe you've assumed facts that are not in evidence. Maybe you're misstating evidence. Maybe you haven't laid the proper foundation. There's this whole umbrella of objections where the form of your question is wrong. At least the lawyer thinks it's wrong. During a deposition, there's no judge in the room. So lawyers make the form objection on the record, and then later when they go to use that question and the answer that came after it in court, then the lawyers can discuss the objection with the judge. Otherwise, you'd never get through a deposition because lawyers would, and sometimes do, argue about a question when in the end, nothing literally is going to happen in that room. There's no judge. No one's going to decide. Just move on to the next question. Relevance. I know there's a lot of you out there that say, everything should come into court. Everything's relevant. If I'm a juror, I want to know everything. Do you? Do you want to know everything? Lawyers and judges, I think, generally do a really good job of trying to figure out what matters in this case. And a witness's credibility always matters, but it needs to be related to the case. You can't just say, hey, this person was a liar in 6th grade. Hey, this person cheated on their spouse. Hey, this person cheats on their taxes. Because the question before you isn't, is the person generally honest or not? That's not the question. The question is, are they telling the truth in this specific thing? But the law doesn't allow character evidence. It doesn't allow you to show action and conformity therewith. Meaning, just because you did something in the past, your prior action means you're going to conform with what you did in the past now. The danger is that you can make someone unlikable, so the jury rules against them even though they didn't do anything wrong. So we rein it in.